Thank you very much, Josh. We now have Rick Faulk from Gardere in Houston.
Well, thank you, Henry. Everybody heard enough about public nuisance? It's an extremely complicated subject, I think, as everyone has heard. It can get complex. But since this is a judicial education program and we're, I think, officially labeled as instructors, I thought it might work to have a nice example of what a public nuisance is and a public nuisance is not in about as simple a terms as I can make it for you. So here is the distinction between a public and a private nuisance. I own a house in a subdivision in Houston where Hurricane Ike blew through, okay? I have a tree that grows on my property, and that tree is a very tall tree, and Hurricane Ike blew that tree over onto my neighbor's house. Public nuisance? No, obviously not. It's a dispute between private property owners, no problem whatsoever. But let's just say I came home and the fates had it that the wind blew a different way, and the tree went across the road in front of my house and blocked a public thoroughfare. Public nuisance? You bet. It is a public nuisance because it interferes with a public right to use a public thoroughfare. And under those circumstances, that in a microcosm is a simple explanation between the two. There probably are some wrinkles there that I'd probably disclaim if we got more complicated. Maybe I'd think up some good defenses, but that's about it. So how do we make that relatively simple definition, how do we change that into this gigantic problem that is going on, that everything from lead paint to subprime mortgage situations to global warming are now all public nuisance situations? Well, it's a matter of scale, isn't it? That's what the other side, the plaintiff's lawyers here, would like for you to see. It's a matter of scale. When the problem just gets so big, and the nuisance is such a big problem, and it involves such a major issue, it's got to be a public nuisance. For example, in the city of Cleveland, where there are hundreds of homes, maybe thousands of homes that are dealing with foreclosure issues, all of which stem from individual contracts between individual lenders which have gone into individual foreclosures. The fact that there's a lawsuit that might lie between the individuals and their lenders is irrelevant. Is it? Is it? Is that an interference with a public right? Can you transform a private problem into a public right simply by the number of people that are afflicted by the problem? If my tree falls and it hits 5 houses because it's a giant sequoia, does it transform it to a public nuisance? And the answer is no. The number of people affected by a problem, whether it's major portions of the city of Cleveland, doesn't transform it into a public right. It doesn't transform private transactions and private rights into things that affect the public interest. Even if those houses are allowed to deteriorate after the banks that foreclose upon them cause a problem, even if they deteriorate and they have to have rodent control and they become crack houses. Well, who's responsible for creating the public nuisance in those circumstances? It's the person in possession of the properties at the time they deteriorate. And that was the holding of the Supreme Court of Rhode Island in the famous lead paint decision that came down last year, that you can't say that the paint manufacturers are responsible for creating a public nuisance here, when in fact you have private residences where the landlords or the owners themselves are allowing the circumstances to deteriorate to cause a problem. And so there wasn't a public nuisance in that case. There wasn't a public nuisance in that case because the persons responsible for controlling the premises at the time the nuisance allegedly occurred were the ones in control of it. They were the ones in control that could abate it. Those were the persons who could have prevented it. And so there wasn't a causal link in the circumstances. So you have two things you have to look at, and they apply in every public nuisance case. What's the public right? Is it a public right, or does it really derive from private situations that people are trying to aggregate? You know, we can't get anymore. Class actions are hard to get, so let's aggregate them and say, oh, well, we don't even have to have the individual landowners involved. We don't have to have the landowners or the property owners of all these homes in Cleveland involved. We can sue the lenders, and we don't even have to specify who owns all this property. We don't have to even specify who owns all the property in Rhode Island that was contaminated. So under those circumstances, there's no public right involved. And so shouldn't the persons, as a matter of common sense, if you're talking about a straightforward analysis, shouldn't the persons who are responsible for creating the nuisance at the time the injuries occurred be held responsible? The persons who are in control, the answer is yes. So both of those issues apply. Now let's go to global warming. And you know, I have done a lot of work in the global warming area and done a lot of research. I know Eric's done a lot in these areas. But you know, is that the ultimate public nuisance? I mean, let's think about this. Well, the air we breathe has got to be something that we all have a public right in, right? Okay. So everybody says, oh, let's concede it. Okay, that's number one. And the refinery down here in Pasadena, Texas, that's emitting all of these greenhouse gases into the environment is contributing to some degree to the global warming exercise, subject to a Daubert motion, okay? But still, it's contributing. So at least, let's say, you get past the motion to dismiss, don't you? Because they can just ratchet down their emissions. They're in control of it. So haven't they really satisfied both of those standards? Now, wait a minute. You all are judges. Most of you, except for those from Louisiana, are common law judges. And you know that the common law is not something that moves quickly to accommodate new and different ideas. You know that the common law is referred to as something that changes in a molecular, or they call it a molar fashion. I found that in an article by Justice Holmes. And what it basically means is that the common law chews on things for a while before it swallows it. I mean, that's what it's all about. And so naturally, I would think if Eric walks into your court and says, I represent 5 Indian villages, Inuit villages up in Alaska, and you're a Texas common law court judge, and they say ExxonMobil in Pasadena is responsible for that, you're going to chew on that for a while. You're going to think about it, and one of the things you're going to think about is, well, let's see. What standard am I going to apply to determine whether ExxonMobil, in compliance with its permit issued by the state or federal authorities to release these emissions, should be held responsible for impacting and creating something known as global warming, which is, by its very definition, an international phenomenon, and probably contributed to by everyone, including all of us when we exhale in this room. So as you chew on this a while, you're probably going to come up with the same answer that you're going to come up with that the trial courts in California have come up with, and they say, wait a minute, this is not a justiciable controversy. This is not something that the courts want to jump into. And, you know, I imagine most people think, oh gosh, I'm here, I'm going to make the whole decision on global warming in my court. You know, I'm going to issue the definitive ruling. I'm going to have the mother of all Daubert hearings, and I'm going to declare an issue from my court that global warming is a man-made phenomenon and it's caused and contributed to by ExxonMobil, and it's impacting people in Alaska. Well, when you chew about that, you'll find that those courts have had a very, very rational approach. They've said that global warming is an international issue. It is being addressed by the political arms of our government in the context of negotiations with other governments. It is a matter that cannot be resolved on an individual basis. It cannot be resolved on a national basis. It must be resolved on an international basis. And who is the best branch of government to make those decisions? The executive branch is, not the judiciary. And so it's not your problem. It's not the judiciary's responsibility to resolve this massive problem, even though, if you just strictly construed public nuisance in the manner that we talked about earlier with the tree, you could say, well, maybe so, subject to defenses. But guess what? You don't have to decide it. And you shouldn't decide it. It's, you know, how far be it from me as a practicing lawyer to tell judges, you know, about making decisions. But having been affected by a number of them, I can tell you that there are some decisions that judges simply should not make. There are some records, some evidence gathering procedures that are simply beyond your resources, and that are wisely entrusted to Congress, who has massive evidentiary gathering capabilities, wisely entrusted to the executive branches of government. That's why we're structured the way we're structured. And so, you know, maybe, just maybe, Eric will get to a jury on his case to decide whether or not the Inuits in Alaska can sue Exxon and any number of other people for what's going on. And then they'll have to get to the mother of all Daubert hearings. And then, of course, that could, you know, you guys could retire on that. That could go on forever. And then you have to get to the point of, well, is there a causation here? And Eric's come up with a very good answer to that. He says they're all engaged in a conspiracy to deny that global warming exists, and they've inhibited research, and so they're all jointly liable. I don't have to sue everybody. Maybe so. But I suggest to you that you're a long way away from having to make that decision. And maybe if you just keep chewing on it, you'll find out that maybe you just want to spit it out and not swallow it. Thanks.